Hi, I'm Brian Heidelberger, a partner with the law firm of Winston & Strawn in Chicago, and here today with another mini advertising law lesson. Today's law lesson, the California Attorney General just recently issued recommendations on developing a meaningful privacy policy. Flash notice, your privacy policy sucks. So let's fix it up, and how do we do that? Well, the background here is that California has a law called CalOPPA, which was issued in 2003, and basically it applies to people who operate websites and collect personal information from Californians, which is basically probably any website. What does it require? Simple. Say what you do and do what you say, and it requires you to have a privacy policy to tell people what you do. In that law, there are a bunch of different requirements which you may or may not already have within your privacy policy. The Attorney General has recently said that most privacy policies, surprise, surprise, are very long and difficult to read, and research shows that most people aren't understanding them or even reading them. So it's issuing now these best practice guidelines to encourage companies to create privacy policies that are easy to understand and use plain language. Now, this isn't the law, we should be clear about that, but it does clearly identify what the California Attorney General at least believes is false and deceptive. So what do they talk about? Well, the first thing is readability. They want you to use plain and straightforward language. Many privacy policies, if you analyze them using the appropriate tools, you'll find are at a 10th, 11th, 12th grade reading level. You really want to get that down to a more 6th or 7th grade reading level. And you do that by avoiding technical and legal jargon. I know, shocking coming from a lawyer like me, but you want to also use it in a format that makes the privacy policy readable. You want to use graphics and icons in titles, use the active voice, use really short sentences, and also consider translating it to other language to the extent that you have a large portion of your customer base who speaks other language, and you know that. What else do they talk about? Well, online tracking and do not track. In 2013, the California law included disclosure requirements about online tracking. Basically, the idea of the law is that if a browser has a do not track signal and consumers use that do not track signal, consumers should understand whether or not they respond to that signal, how they respond to that signal, as well as whether other third parties are conducting tracking on your website. You'd really be amazed if you use the appropriate tools and you check out your own website, you might find that there are a lot of third parties who had gained access to your website and are doing tracking on your website without you even knowing it. So the California Attorney General has said you need to disclose those things, and you should really make it easy to understand where that information is by having a link, something like how we respond to do not track signals, or online tracking, or California do not track disclosures. Don't bury it. And they don't want you to just have a link to some third-party program. They really want you to disclose how you respond to those do not track signals. So what else are they concerned about? Well, data use and sharing. If you are using personally identifiable information for more than just facilitating the consumer transaction that you originally interacted with them, they want you to disclose that. They also would like you to disclose the links to privacy policies of third parties that you share personal identifiable information with. Now, are you required by law to do that? No, this is a recommendation of the California AG. They also want you to disclose how long you retain the information, the personally identifiable information that you collect. And that's something I think that a lot of people don't currently include on their privacy policy. The California AG also made recommendations about individual choice and access. Basically, we all might have a sentence that says you have a choice regarding your collection, but the AG wants you to have very clear instructions on how people can see the information that you've collected and how they can change it. And they want you to keep records of people's preferences and log any changes that are requests. And you want to make sure that you ensure that requests to change or to see information are honored in a quick and reasonable time period. You also want to verify the authenticity of anyone who's contacting you trying to see their personal information. They don't want you just giving out that information willy-nilly. What about accountability? The California Attorney General wants you to make it clear who consumers can contact if they have concerns about your policy or about your privacy practice. What they say is give a title of a person, an email address, or a postal address for somebody who can respond to these questions. They also said it might be a good idea to include a toll-free telephone number. In that regard, they want you to train the staff answering the calls to recognize the privacy inquiries and be able to respond to them, as well as customer service staff should have the ability to identify and tell consumers how they can get a copy of your privacy practices. Now that is a very short bit on this long and detailed document, but I think it should give you a really good overview. You should check it out yourself, check with your own lawyer, and check your privacy policy because it may be time to make those updates. In the meantime, follow me on Twitter at Brian Heidelberger, or you can see more mini law lessons at youtube.com/adage or youtube.com/Brian Heidelberger. And until next time, be careful out there.